forth to call this meeting. Call this meeting of the Joint House Senate Subcommittee on Claims to order. Quorum is present. I think we can start the meeting with just introductions. I am State Representative Luke Frederick, District 18B. Been in the House since 2020. Just to start that on the table, we can work this way. Senator Westland.
Good morning. I am Senator Bonnie Westland. I'm from Senate District 42. This is my first term, and I am happy to join the Subcommittee on Claims.
Good morning. I'm Senator Bruce Anderson, representing Senate District 29, which is most of Wright County, just west of the Twin Cities. I've been on claims maybe too long. Seems like I never get off this merry-go-round right now. But anyway, good to be here this morning. Look forward to our presentations.
Hi, everyone. Representative Sandra Feist. My district is 39B, which is in the North Metro. It's the southern part of New Brighton, Columbia Heights, and St. Anthony. I was elected in 2020 along with Representative Frederick, and I am also the Vice Chair of Public Safety. So this is my first time on this committee. Very excited to be here. Thank you.
I'm Jason Keenley. I'm one of the co-counsels for the subcommittee. I'm the Assistant Deputy Revisor.
I'm Maureen Sandy. I'm one of the co-counsels for the committee and an Assistant Advisor.
I'm Sally Olson, and I'm a Commission Administrator with the Legislative Coordinating Commission.
I'm Diane Henry Wangenstein. I work with the Legislative Coordinating Commission as well. I'm serving as the acting claims clerk right now.
Perfect. The agenda was sent to everyone ahead of time. Can I get a motion to approve the agenda for today's meeting?
So moved.
We have the agenda before us. All those in favor?
Aye.
All right. The motion prevails. Can I get a motion for the minutes for the March 29th, 2022 meeting minutes? Motion to approve the minutes.
So moved.
All right. All those in favor say aye.
Aye.
All right. Motion prevails. The next agenda item is the reconsideration of injury claims approved by the subcommittee in the 2021-2022 legislative biennium. Mr. Keenley will do a summary of those claims.
Thank you, Mr. Chair. The injury claims come to the subcommittee through Minnesota Statute Section 3.738. That section states that injury claims shall be determined by the legislature. The Subcommittee on Claims has served the role of reviewing these claims and recommending to the legislature whether these injury claims should be approved and appropriated for. During the 2021, during the House floor debate on the claims bill, a member questioned an award to a claimant. The debate was tabled and the bill was returned to the House Ways and Means Committee, where all the injury claims approved by the subcommittee were removed from the bill. The bill was enacted without the injury claims. In 2022, the subcommittee reconsidered the removed injury claims and reapproved them. The subcommittee also heard new injury claims and approved one. The reapproved and newly approved injury claims were held out of the claims bill in the House Ways and Means Committee again in 2022.
This year, the subcommittee has been asked to limit its consideration of injury claims under section 3.738 to those claimants who are no longer incarcerated or will be released in the upcoming fiscal year, recognizing that the continuing to hold these claims placed an undue burden on these individuals. Other injury claims under section 3.738 will be held over at the end of the hearing. Mr. Keenley will summarize the claims to be reapproved by the subcommittee.
Thank you, Mr. Chair. The first injury claim to be considered for reapproval by the subcommittee is the Nicholas Edwards claim. Mr. Edwards asked for compensation for a partial amputation of his right index finger. Claimant was performing assigned duties in the grommet shop, and he had his right index finger smashed in a grommet machine. He was transported to the emergency room where hospital staff determined the proper treatment was a partial amputation. Claimant has otherwise healed well. DOC staff recommended a payment of $3,750. But the compensation changed around that time, and so there was a higher number for that. So when we reran the numbers, it came out as a 5% rating for the whole body, equivalent to $3,940. Mr. Chair is going to recommend that these can all be done in one motion after I go through these. If you would like to just handle them in one motion. The second one for reconsideration is the Faulkner claim. Claimant Faulkner sought compensation for an injured thumb sustaining while performing assigned duties. The claimant was splitting and stacking firewood when his thumb was crushed by a wood splitter. Claimant was transported to the hospital where he received wound care, and x-rays revealed a fracture at the base of the distal phalanx of the left thumb. Medical records showed that the claimant's thumb healed well, but there was some permanent loss of flexion that equated out to a 5.5% the disability was less than 5.5%. It equated to 0.66% of the whole body, which comes to $520.08. The next one for reconsideration is the Colquet claim. We actually found out yesterday that the Stephen Colquet passed away last year. So the subcommittee has a couple of options on this. They can reapprove it as it was. And we can see if, based on existing general law dealing with what happens with awards to a person, if the just general law can handle this, and the Department of Corrections would have the appropriation with them, and then can see if they can get that to the right people through existing legal process, or we can hold over the claim and see where things are at in a year, given the finding out about this yesterday afternoon. I haven't had enough time to go through all the possibilities on this to figure out what the options are. It does appear that that Stephen Colquet had dependents, but there is not an open probate. So those portions of what we know, that's sort of what we know at this point. So I think, I'll leave it to the subcommittee to determine which of those options is a better approach. Again, I think in either case, there's a good likelihood that we'll be revisiting things, because I'm not sure that there are mechanisms in place. If the subcommittee were to make a recommendation, there would be appropriation to the Department of Corrections that money would in that form be able to get to the people that it would need to go to. And so in that case, the appropriation would expire, and we would be in a place where the subcommittee could then either recommend amending the law that would have appropriated that money, or move on to doing a new appropriation to direct that money as it would need to be directed. That's the background on where we're headed with that. The injury for Stephen Colquet was an amputation of 3 fingers and a partial amputation of a 4th finger. That ended up the compensation amount for the partial permanent disability came to a total of $28,581. Stephen Colquet had asked for lost wages as well. He was not able to provide a lot of documentation for what that wage loss would be. But what the subcommittee recommended in 2021 was to basically triple the injury amount. So 2 times that would be for the wage loss, and 1 would be for the injuries. And that came to, I think, 700 or $85,743. So that is what the subcommittee approved in 2021. The final one for reconsideration or potential reapproval is the Vandevender claim. James Vandevender suffered a traumatic brain injury that was caused when he was assaulted by another offender while performing assigned duties. This is also another complicated claim. When this claim was first brought before the subcommittee, the claimant was still in custody, and so while there were portions of the claim that that the subcommittee could make determinations on as to function loss and rating under the workers' compensation schedule, there were portions of it because of his incarceration at the time the subcommittee could not make determinations on. So unlike most determinations where it's full and final payment, this was for a partial minimum ascertainable permanent partial disability payment of $43,200. So those are the claims that had been previously approved by the subcommittee. And I don't know I think given the cold case situation, I don't know if somebody wanted to make a motion on Edwards, Faulkner, and Vandevender, I think that we could do those together to just reapprove them as they had been previously approved by the subcommittee, and then a discussion of what to do with the Colquet claim would be appropriate.
Chair, I'd like to make that motion that we pay the three, Mr. Edwards, Mr. Faulkner, and Mr. Vanderveer, and lay over the Colquet claim until further information is gotten back to Mr. Keenly regarding the situation of how to pay out his reward. That's my motion.
So Senator Anderson moves that we pay the three at the previous approved levels, and then we lay over Mr. Colquet's. Do we have discussion to that motion? Representative Feist.
Yes, I have a question. If we lay over Mr. Colquet's amount, that would be for an entire year.
It would be until the committee meets next, which is at an unknown time at this point. Mr. Keenan?
And functionally, because they're appropriated for the fiscal year, the appropriations that would be recommended in this bill would be fiscal year 24 appropriations. Typically for the next, whenever the next hearing would be, the appropriations would be for fiscal year 25. Although that's typically happened because it's normally in May by the time that the subcommittee makes the recommendations and the bill is actually passed. That could certainly happen earlier in the year, and then the fiscal year 24. If the legislature were to come back in January, and it would be something that could move quickly, there certainly in that case would be time to do a fiscal 24 appropriation. But for the most part, anything that's laid over will become an appropriation for the following fiscal year.
Yes, there's no way to just do all of our business today except for this and then figure out about family members and procedure and come back in 2 weeks and just add that in.
So, as far as the process by which the claims go into a bill is there's a recommendation from the subcommittee that then gets put into a amendment for the bill shell that's parked in the House Ways and Means and Senate Finance, and then those amendments are put into that. It's certainly possible that that we could make amendments to that bill what I have found out so far from the Department of Corrections is it sounds like the children in that case are currently under a CHIPS proceedings, so I'm not sure that that would be resolved in the course of before session is complete. So again, working here with certainly incomplete data. But I'm not sure that we will have a full picture of what the situation is before the end of session.
If I could just, finish my thoughts, sorry. So, okay, thank you, so that's really helpful. I do think that once we do have full information, if we could move as fast as this process permits, I think that would be good. Thank you.
Senator Carlson?
Yes, Mr. Chair, I guess I'm asking, what are the decisions that have to be made and are they within the purview of this committee? Or are they recommendations that come from council on how you distribute this? Because we're approving the amount, I believe, but not necessarily the distribution. And that distribution is going to come from the recommendation to council, I would figure. And so can we approve the amount with the stipulation that council will determine how to distribute?
Thank you, Mr. Chair. It's largely governed by the words that we put into the bill. We typically make these as applications to the department for full and final payment of the claim to the claimant. And so what that then triggers is basically a document that says that the claimant needs to sign that says I am signing away any additional legal rights that I have to this claim in order to receive this money. And again, that's sort of based on the language that we put into the bill. There have been instances in the past where there have been where not in the Department of Corrections world, but in other claims where claims have been paid to the estate of whomever. In this case, because there's not probate open and I'm not sure exactly sort of the legal landscape of where we would need to be appropriating that to and who the appropriate party is to appropriate that to. I'm not sure that we can put that in the bill. Again, we could appropriate it to Stephen Colquet, and if general law provides a mechanism by which somebody can go and be in his behalf and sign that document that says this is the end of this legal, it extinguishes the legal right, then that money could be paid. If no one is able to do that under general law, then we would be sort of back here if we were to make the appropriation to the claimant. I'm not sure that we have enough information at this point to make an appropriation to anyone besides the claimant, because I'm not sure what legal structures we would be, what structure we would need to appropriate, who we would need to appropriate that to. We would be appropriating to the Department of Corrections, but how they would handle that needs to be dictated in the bill itself.
So I'm just gonna say this, that I think Senator Carlson, I think the idea of approving that money, I think I'm supportive of as well. But I think some of the challenges that Mr. Keenly is identifying, especially since some of this just came to light yesterday, I believe, it puts us in a situation that is a bit challenging too. So, and I think if I'm reading Representative Feist as well, that it's there's a desire to approve this money. I think what we are just trying to determine is, the best way to do that. Representative Pond.
Yeah, I think in this case, prudence of not making an error in verbiage, it is better, because if it's going into this process, I don't think that's long enough of a process to where if we address this in our next meeting, even if that's next year, it still would be in line with the other activities going on.
And my general understanding is that the children in this case are fairly young. I think we're talking 5 or 6 and under. So.
So just to remind the committee, the motion before us right now is to approve the other 3 claims and to lay over the Culcade claim. Was there any other discussion, Senator Westland?
Just one quick question, and I think I've got the answer, but I just want to make clear, so with the vendor claim, this is a partial claim, but there are potential future claims, and this will not foreclose him from making that future claim. Is that correct?
Mr. Keeney.
Mr. Chair and Senator Westland, that's correct.
Any other discussion on the motion? All right, all those in favor of the motion, say aye.
Aye.
All those opposed? The motion passes. Next agenda item is the exoneration claims. The first exoneration claim is the Buchner claim. Mr. Kingsley will summarize the claim.
Thank you, Mr. Chair. In 2006, claimant Buchner was released on a conviction unrelated to this claim. The Department of Corrections determined at that time that claimant was required to register as a predatory offender based on a prior Wisconsin conviction. In 2009, 2011, and 2017, claimant was charged with failing to register as a predatory offender. Each time claimant pleaded guilty to the charge. Claimant served 7 periods of incarceration for the offenses and supervised release violations. In 2019, claimant filed a post-conviction relief petition on the basis that claimant's Wisconsin offense should not have triggered predatory registration. The relief petition was granted in August 30th, 2019. Claimant filed 3 petitions for an order declaring eligibility for compensation pursuant to Minnesota statute section 590.11. The petitions were granted on August 22nd, 2021. The claims were filed with the Minnesota Supreme Court, who consolidated the cases and appointed a compensation panel. The state and claimant moved for summary disposition of a settlement totaling $810,431.86. $791,506.96 was the stipulated amount for the statutory base rate, and $18,925 were for attorney's fees. Hearing and payment are recommended. And I did get information yesterday regarding how that was broken down. As far as the statutory base rate for the incarceration and the time on the time for supervised release and the time for on the predatory register list. So I can give a little bit more detail on that. So for the time that he was on the registered as a offender, it was 14 years and 240 days. So the statutory amount for that was $366,438.36. And then on the first conviction, there were 3 periods of incarceration that totaled 2 years and 165 days for a statutory compensation of $122,602.74. The second conviction, there were 4 years, 342 days served for a statutory minimum of $246,849.32. And for the last one, 406 days for a compensation of $55,616.44. So all of those added up are the $791,506.86.
We have a motion to approve or deny or lay over. Representative Quam.
I do have a query. What's the delta between the 810 and the amount you just quoted?
The attorney's fees.
So that was it, okay. And also for clarification, who was it a court determination or who, what entity actually made the decision that the prior conviction in Wisconsin didn't justify the registration?
Mr. Keating.
Mr. Chair and Representative Plum, that was a court decision, a court order.
Mr. Chair, I'm moving the payment of the Carol James Buckner claim for exoneration.
Senator Anderson moves to approve the James Buechner payment. Any discussion to the motion? Seeing none, all those in favor say aye.
Aye.
All opposed, say nay. Motion's approved. The next exoneration claim is the Fairbanks claim. Mr. Keenly will summarize the claim.
Thank you, Mr. Chair. In 1994, claimant Fairbanks was found guilty of a crime for which he was required to register as a predatory offender. In 2016, claimant was arrested and charged with failure to register. Claimant pleaded guilty, but later appealed his conviction, requesting to withdraw his plea. The crime of failure to register requires that the person knowingly violate the registration statute. In 2013, claimant suffered a traumatic brain injury that caused him to develop substantial cognitive and memory deficiencies. Due to these deficiencies, the court at rehearing found the claimant did not knowingly violate the statute and should not have been allowed to plead guilty. Claimant filed a petition for an order declaring eligibility for compensation pursuant to Minnesota statute section 590.11. The petition was granted on December 11th, 2020. Claimant spent 274 days in prison on the conviction. The claim was filed with the Minnesota Supreme Court, who appointed a compensation panel. The state and claimant moved for summary disposition of a settlement totaling $56,008.26. $37,508.26 is the statutory base rate for the amount of time in prison, and $18,500 is for attorney's fees. Hearing and payment are recommended.
Discussion. Is there a motion?
So moved.
Representative Fights moves to approve the payment. Is there any discussion of the motion? Seeing none, all those in favor say aye.
Aye.
All opposed say nay. Motion is approved. Final exoneration claim is the Vento claim. Mr. Keenly will summarize the claim.
Thank you, Mr. Chair. In 2012, claimant was charged with felony DWI test refusal for refusing a chemical test. Claimant pleaded guilty to the charge and was sentenced to 42 months in prison, which was stayed. Claimant committed several probation violations, and claimant's sentence was executed on June 26th, 2020. Claimant filed a post-conviction relief petition on the basis that the statute that claimant was charged under had been found unconstitutional. Claimant was released on June 2nd, 2021, while the relief petition was pending. The relief petition was granted July 2nd, 2021. Claimant filed a petition for an order declaring eligibility for compensation pursuant to Minnesota statute section 590.11. Petition was granted on January 11th, 2022. Claimant spent 529 days in prison on the conviction and 30 days on supervised release while not serving time for any other conviction. The claim was filed with the Minnesota Supreme Court, and the court appointed a compensation panel. The state and claimant moved for summary disposition of a settlement totaling $240,000. $74,469.54 is the statutory base rate for the amount of time in prison and on supervised release. $88,418 is for economic damages, $62,112.46 for non-economic damages for physical injuries and sickness during incarceration. $15,000 is for attorney's fees. Hearing and payment are recommended.
Discussion. Is there a motion?
Yeah, I move that the claim for Joe Maria Vento be paid based on the testimony from counsel.
Senator Anderson moves for approval of the payment. Is there discussion of the motion? Seeing none, all those in favor say aye.
Aye.
All opposed say nay. Motion is approved. The next item on the agenda is the reimbursement to the Department of Corrections for injury claims paid to Mr. Mr. Keenly will summarize, sorry, let me repeat. Injury claim paid, Mr. Keenly will summarize, the claims.
Thank you, Mr. Chair. Yeah, I don't receive compensation. Any of these. I'll start by saying there were three, well, let me start by saying how these occur. These claims come to the subcommittee. They have already been paid by the Department of Corrections. These are paid for claimants who are already out. These are sentenced to service and other community service type programs. So these are people who the Department of Corrections does not provide medical services for because they are out in the community. So what these are reimbursements for injuries that happen to them while they are, I'll use a example that I think people understand of like picking up trash on the side of the road. It's those types of things. If somebody were to get injured during that, and needs to go to, a doctor to see for medical costs, those costs are reimbursed by the Department of Corrections, and then the subcommittee reimburses the department for those payments. So last year, there were 3 of those claims that came to the subcommittee that totaled $2,446.98. Those had been approved by the subcommittee, but did not make it into the final bill last year. This year, we received one additional one for $521.14, for a total of $2,968.12.
Is there discussion, Representative Quam?
I would move to pay these and include it in our bill.
Representative Quam moves to approve this amount. Is there discussion to the motion? Seeing no discussion, all those in favor say aye.
Aye.
All those opposed say nay. Motion is adopted. Next item on the agenda is the Department of Corrections injury claims. The first injury claim is the Dimart claim. Mr. Keenly, will you summarize the claim?
Thank you, Mr. Chair. Claimant Dimart asked for $1 million for failing to protect him from contracting COVID-19 and the health issues that followed when he did. Claimant contracted COVID-19 while being in the New Dimensions program. While claimant did perform assigned duties during the time period when he was in the New Dimensions program, claimant did not establish that he contracted COVID-19 while performing those duties rather than from his general living environment. The subcommittee only has exclusive jurisdictions over injuries that occur while performing assigned duties. The subcommittee rules prohibit bringing claims that can be brought in court. Unless a court determines that the claim falls under the exclusive jurisdiction of the legislature in applying Minnesota statute section 3.738, a district court would have jurisdiction over this claim. Hearing and dismissal are currently recommended. If a court subsequently makes the determination the claimant's claim must be brought under Minnesota statute section 3.738, further discovery and hearing are recommended.
Mr. Chair,
Senator Anderson.
is there someone here to speak on behalf of Mr. Diamond? Or is that?
Mr. Keenly.
Mr. Chair and Senator Anderson, Mr. Diamond is still currently incarcerated.
Okay.
So.
Any follow-ups, Senator Anderson?
I was just wondering if there would be, if he has counsel or any type of person that would be representing him, even though he's incarcerated, but to bring this kind of a claim, it would be.
Well, if I'm tracking the recommendation, it's just saying that the appropriate path for this type of claim would go through more of the court process than it would be coming before us. So the recommendation for now would be the recommendation from council is for us to deny the claim to allow it to go through the appropriate channels in the court, if I'm summarizing correctly, Mr. Keenly.
Yes, Mr. Chair, and I would use the terminology dismiss at this point rather than deny because.
Thank you.
Well, we're slightly different procedures.
Fair enough. Any other discussion? Senator Carlson.
I would move to dismiss that.
Senator Carlson moves to dismiss the claim. Is there any discussion to the motion? All those in favor say aye.
Aye.
All opposed say nay. Motion's adopted. Next item on the agenda is the Meyer claim. Mr. Keenly, will you summarize the claim?
Thank you, Mr. Chair. Claimant Meyer asked for compensation for skin issues claimant states are a result of a chemical burn from a detergent that sprayed on him while performing assigned duties in the facility's kitchen. In August of 2022, claimant sent a kite and filed a claim that exposure to detergent that had sprayed on him in April had caused an ongoing rash. Health records from May show claimant was seen by health services for rashes. Chemical or detergent exposure was not noted in either record, nor was any rash on claimant's arm noted. The rash on claimant's arm was noted by the officer who took the workplace incident report in August. There's insufficient evidence that claimant's rash was caused by exposure to detergent. Hearing and denial are recommended.
Any discussion?
Mr. Chair,
Senator Anderson.
Mr. Keenly, were there documentation that the doctor felt that this language or felt that this individual may have gotten this rash while at the facility?
Mr. Keenly?
Mr. Chair and Senator Anderson, there is not. The location of the medical records speak to the location originally of behind the ear. The claimant brings a claim for, or in their claim, claims that the detergent had been on their neck and their arm. I guess behind the ear could be considered part of the neck, but there's sort of a misalignment between what the claimant is asking, the timing and the medical records not reflecting any, and this is sort of moving beyond what is there, but in a typical situation, had there been, had the claimant suggested that there had been chemical exposure in those early medical meetings, that would be reflected in the medical notes that there had been some level of exposure. The other portion of this is that there was no workplace incident filed, that there was this exposure until 4 months after the incident happened. And there was no department. There was no one from the department who witnessed this. So there's a level of which what happened during the workplace incident, there's a large amount of hearsay to what happened. And that hearsay is not supported by what is in the medical records that were timely that occurred at the time.
Mr. Chair,
Senator Anderson.
Mr. Keenly, I was in just reading what he had written here, or what he's written, that he is going to see a dermatologist. That's why I asked if there was any type of correspondence or anything from a dermatologist regarding this situation. So that's a concern. So you answered the question. Mr. Chair, I move to dismiss the claim.
Senator Anderson moves to dismiss. Is there discussion to the motion? Seeing no discussion, all those in favor say aye.
Aye.
All opposed say nay. Motion is adopted. All right, the next item on the agenda is the Department of Corrections property claims. We'll first take the claims that have been recommended for hearing by council and then ask for any other claims that members would like to be heard. Ms. Sandy will summarize the claim number 12 on the agenda, the Davis claim.
Thank you, Chair. As you've stated, the first thing that I've recommended for hearing is the property claim for Harold Davis. Claimant Harold Davis filed a property claim for $166.58 for a missing photo album and photographs. On February 25th, 2022, claimant was transferred to a restricted housing unit and DOC staff popped up an inventory claimant's property. On March 11th, 2022, claimant retrieved his property and reported that the photo album and photographs were missing. Per DOC policy, photographs and photo albums are not inventoried. They're typically not tracked. However, DOC staff confirmed that the photos were tracked. DOC offered claimant $3.38 for the cost of the album, $25.20 for the cost of the photo protectors, and $10 reflecting the maximum allowable compensation for photographs. That totaled an offer of $38.58. Claimant rejected the offer. As DOC staff acknowledges the loss of claimant's property, there is sufficient evidence that staff action was responsible for claimant's loss. Council recommends the hearing of this claim and reoffering that $38.58 to settle the property.
Discussion. Representative Weiss.
Do we have any monetary value for like the emotional distress or the fact that they've lost something sentimental to them? Or can we only look at the like literal cost of the album and the protectors?
Ms. Sandy.
Thank you, Mr. Chair. Representative Vice, per subcommittee's rules, we don't look at emotional distress for property claims. For other types of claims we may. And currently, it's up to the committee on the total amount. And so we leave that up to you guys to decide. But there is the DOC policy of the maximum allowable for the photograph, so that's also something to consider.
Representative Quam.
One of the things, over the years on this committee that I always keep in mind is, setting precedents. And following current practices, I think would be prudent in this case. And therefore I would move to, accept the recommended, $38.58.
Representative Quam moves that we approve the recommended amount of $38.58. Is there discussion of the motion?
So, Mr. Chair,
Senator Anderson.
we're asking the DOC to reoffer the $38.58 back to the claimant.
That the motion is for the committee to approve that amount for DOC to reoffer. Yes.
Thank you.
Any other discussion? All right, all those in favor of the motion, say aye.
Aye.
All opposed, say nay. Motion is adopted. The next claim recommended for hearing is claim number 28 on the agenda, the Nielsen claim. Ms. Sandy will summarize the claim.
Thank you, Chair. Claimant David Nielsen files a property claim for $644 for a TV, tablet, photo album, headphones, and 2 necklaces. On July 15th, 2022, claimant was transferred to the restricted housing unit. Department of Corrections staff packed up and inventoried his property. The incident report shows that claimant's TV was damaged, and the inventory report shows that staff confiscated the TV per their policy. Claimant retrieved his property on July 25th and signed off on the property report. Because the damage to the TV was noted at backup, there's insufficient evidence that staff is responsible for the damage. Council recommends denial of the property claim for the TV. On July 28th, 2022, claimant was again transferred to the restrictive housing unit and staff packed and inventoried his property. One disposition record shows that claimant shipped out 2 necklaces, and another shows that the headphones were confiscated because they were not on claimant's property report. There's insufficient evidence that staff is responsible for these items, as claimant chose to ship them out and the others were not his. And council recommends denial of the property claim for the necklaces and for the headphones. Regarding the photo album, claimant filed a property claim for it before retrieving his property on August 4th. As stated, photo albums are not tracked on the property reports. However, the property disposition record notes that staff had checked the property and verified that the photo album was in claimant's property. Claimant later signed the property report, and the record does not indicate that the photo album was no longer present. Therefore, there's insufficient evidence that staff is responsible for this item, and council recommends denial of the property claim for the photo album. The record reflects that during the July 28th pack-up, claimant owned a new tablet, but it was not put on his property report. Claimant reported it as damaged when he retrieved his property and staff confiscated it. The Department of Corrections offered to compensate claimant with $139.62, given that there was a lack of evidence of the condition of the tablet when it was packed up. Claimant did not respond to the offer. However, council recommends reoffering this amount for the property claim on just the tablet.
So discussion. There a motion?
Mr. Chair, I'll move that we recommend that DOC's offer to resolve the claim for $139.62 back to the claimant, and hopefully he'll we think the claimant accepted.
Senator Anderson moves to approve the reoffering of the $139.62. Is there discussion to the motion? All those in favor say aye.
Aye.
All opposed say nay. Motion is adopted.
Mr. Chair,
Senator Anderson.
this particular claim for Mr. Nielsen, I received a duplicate copy of that because the language had been cut off on the bottom here. Well, as I'm going through the claim, I find another, and I'm just making this as a reference, for Mr. Victor Shelton, which it looks like in the same comments, the claim of the language was cut off on that particular claimant also. I'm just making that as a reference for future as we go forward, so don't want to belabor the issue, but just want to make sure that we look at this going forward. Thank you.
Thank you, Senator Anderson. I know the packet is a very large packet. The staff do the best they can, so I'm sure they'll keep an eye out for that in the future. All right, the final claim recommended for hearing is claim number 46 on the agenda, the Mario Williams claim. Ms. Sandy will summarize the claim.
Thank you, Chair. Claimant Mario Williams files a property claim for $87 for a damaged hot pot, a missing remote, and missing canteen items. On January 24th, 2022, claimant was transferred to the restricted housing unit. Department of Corrections staff packed up and inventoried his property. The incident report notes that all of claimant's electronic items were verified and in working order. Claimant retrieved his property on January 26th and signed the property report. In the property report notes, staff wrote that the hot pot was damaged. The property disposition record also lists the hot pot as broken. Because the incident report stated that all the electronics were working, first, staff determined that claimant's hot pot was damaged in the property department. The Department of Corrections offered $27.29 to compensate for the hot pot, but claimant declined the offer. Regarding the remote, the property report indicated that the remote was present. On February 3rd, 2022, claimant again was transferred to the restricted housing unit and staff packed and inventoried his property. The property report shows that claimant's remote was missing and not packed by staff. The incident report also notes that the remote was missing. Regarding the claimant's canteen property, per DOC policy, canteen items are not tracked. The incident reports state that claimant was over the required 2-bin limit. The property disposition record also reflects that claimant's canteen items were over the limit, but that items were given back to him on February 11th. Given that there is insufficient evidence that staff action is responsible for claimant's missing remote and for the canteen property, as those items are not tracked. Council recommends denial of the remote and the canteen items. Council also recommends reoffering $27.29 for the property claim on the damaged hot pot.
Their discussion. Their motion.
Mr. Chair, move that we have the council reoffer the $27.29 to the claimant, and we approve the claim as presented to us.
Senator Anderson moves that we approve the $27.29 for the damaged top pot. Is there discussion for the motion? All those in favor say aye.
Aye.
All opposed say nay. Motion is adopted. If there are any other property claims that council has not recommended for hearing that members on the committee would like to bring up, this would be the time to do so. Not seeing anything. Representative Kwong.
I'd like to move to, take the recommendations of the council and, approve those recommendations that I've stated.
Representative Kwong, that would be to approve or deny, the recommended, the rest of the per council recommendations. Like,
It'd be simpler if I just say that I move to deny the remaining claims.
claims, okay. Representative Kwong moves to deny the remaining claims. Is there discussion to the motion?
Mr. Chair, we want to limit that to the property claims.
To the,
Remaining property.
remaining property claims. Discussion to the motion for denying the remaining property claims. Seeing no discussion, all those in favor say aye.
Aye.
All opposed say nay. Motion is adopted. This brings us to our final agenda item, holding over pending claims that we did not hear during today's meetings. Is there? You're looking for a motion to. Motion to hold over the remaining claims. Senator Westland moves to hold over the remaining claims of the discussion of the motion. Seeing none, all those in favor say aye.
Aye.
All opposed say nay. Motion is adopted. All right, thank you everyone today. The meeting is adjourned.
Mr. Chair,
Representative Kwong.
the reason for the clarification of the delta between the 800 and the other
Yeah.
was for public record. I didn't want somebody to,
That was a good question.
okay.